Good morning, everyone. Welcome back to the channel. We have some breaking news for you guys today coming from one of the Proud Boys cases. We have more allegations of FBI misconduct. We just reported on this like last week. There was another issue of FBI misconduct, and the jury had to be taken out and dismissed for the day as they argued back and forth about the FBI and their corruption, basically. Before we get into that, though, I just want to say thank you to the members of the channel, people who have signed up and subscribed to support the channel monthly as a member. I really appreciate that. I know I just saw a new person joined and became a member. Thank you so much for that. I really appreciate it. A lot of the things that I talk about on this channel are things that, YouTube and the powers that be deem controversial. So most of my videos are demonetized, and I really appreciate you supporting my work that way. I have people on locals. My locals is radixferrum.locals.com. I'll have links to that in the video description. I have people supporting me there monthly as well, and I really appreciate it. And if you haven't joined the locals community, it's completely free to join. I welcome you to do so, and I'm going to make an effort to try to be more active there because we have to start using these alt tech platforms, especially ones that are responsive to us like locals is. All right, let's go ahead and get into this. Oh, and by the way, if you're new here, welcome. My name's Radix. I talk about a lot of things on this channel, lots of breaking news, or just I do deep dives into stories that I'm interested in. I try to look at things that are maybe under reported in the mainstream news. I'm working on a documentary on the Michigan Whitmer Fednapping hoax case, and so I have a separate channel for that where you can go watch the trailer for that documentary. We're currently fundraising for it. I'll include those links in the video description as well. But it seems like more and more each day the FBI is being exposed. We are seeing how they really work, behind the facade of what we're told is the world's premier law enforcement agency. You have a sprawling bureaucracy that is putrid and wicked at the core. And it is not just at the top in DC. I know that that's something that a lot of people believe, and these are sort of talking points, oh, it's just a small number of people at the top that are corrupt, and careerist and in this and that, and it's just where the concentration of power is. But then at these regional or, state and local FBI field offices, it's different. That's not true at all. And I think that people are starting to see that more and more. And I think that that's important for people to understand, how things really work versus how they're portrayed to us in fictional stories and popular culture. Hollywood movies, the way that they portray these federal agents is very different from like what the reality of that job is. It's very glamorized. You have also shows like Law and Order, the CSI shows that give people this false perception. And I think that it's important that that illusion is shattered and that more and more people are waking up to this, as we also have the weaponization of the federal government committee supposed to be investigating abuses of different federal agencies and how they had been weaponized. And so I think that this is a very egregious example. So this is coming from Julie Kelly. Breaking news: just when you think the DOJ can't get any dirtier, a new motion was just filed by the defense in the PB's trial, accusing DOJ of using an FBI informant to spy on and infiltrate the defense team. So, defendants' corrected motion to compel disclosure of all FBI interview reports and all DOJ memos relating to the recording and reporting of the defense team. And by the way, if you haven't watched my prior video on this from, I think it was like last week, I'm going to include a link to that video in the video description here. You should pause this and go watch that first, because you should have that background information prior to this. But basically, the FBI supposedly accidentally sent over information that indicated that the FBI had been spying on attorney-client privileged communications of the defense team, and then they were discussing kind of back and forth whether they thought that the defendant was going to take a plea deal and this and that. They're not supposed to be doing stuff like that, okay? It's just unbelievable. Anyways, okay, so, and then come back and watch this after you watch that one. If you have watched it, though, you already know about what happened last week, so it just continues. Defendant Zachary Rehl, through counsel and pursuant to the Due Process Clause of the Fifth Amendment, Sixth Amendment, and the court supervisory power, respectfully moves the court for an order compelling the government to disclose to the defense all reports, e.g. FBI 302 reports and recordings that have been prepared in this case relating to any person, including but not limited to confidential human sources and any other witnesses the FBI communicated with regarding the possibility of any recordings or reports it may have regarding the defense team. All interview reports or FBI memos relating to the recording or reporting of the defense team, and all internal memos prepared by the U.S. Attorney's Office and DOJ relating to any reporting on and recording of the defense team. They should not have any recordings of the defense team. That's just insane. Mr. Rehl is filing this motion on his own behalf and on behalf of all defendants with the consent of their counsel. Rehl and defendants are herewith preparing a separate motion to dismiss the indictment or for an evidentiary hearing raising serious and substantiated allegations. And that's an important point, that they say these are not just allegations, but that they are substantiated, that basically they've got evidence to back this up. They're not just making claims here. So DC U.S. Attorney Matthew Graves, who just recently announced his intentions to do a second J6 Shock and Awe campaign, his office has notified defense team today that a defense witness has been an FBI informant since the beginning of the case through start of trial. Quote, the CHS participated in prayer meetings with defendants' families. So this is a great way for the federal government and Department of Justice to be able to spy on, the defense team in a high-profile case, and a high profile, and I should say political case, which is just unreal. Okay, government misconduct surrounding the surreptitious invasion and interference of the defense team by the government through a CHS, that's an FBI informant, at the government's behest. This instant motion is based on a disclosure made to defense counsel today, March 22nd, 2022, at the end of court's proceedings, wherein the government stated that one of the witnesses who was disclosed to the U.S. and the court as directed by the court in December 2022, who was scheduled to appear in the defense case the following day, has been serving as an FBI informant since April 2021 through at least January 2023. During this period of time, the CHS has been in contact via telephone, text messaging, and other electronic means with one or more of the counsel for the defense and at least one defendant. During this period of time, the CHS also participated in prayer meetings with members of one or more of the defendants' families. The CHS also engaged in discussions with one of the defendants' family members about replacing one of the defense lawyers. So you have an FBI informant undercover inserting themselves into the defense of a case that they're trying. So they infiltrate the defense. You're supposed to have a constitutional right to a fair trial. And they use an FBI informant to go suggest that, hey, you should fire your current defense lawyer and maybe replace them with somebody else. The above may not include all the communications that were initiated by or engaged in by the FBI informant. The allegations about the existence of yet one more previously undisclosed CHS after various other alleged full and complete disclosures of all the CHSs involved in the case demonstrate that there are reasons to doubt the veracity of the government's explanation and justification for withholding information about the FBI informant who have been involved in the case. Moreover, the government disclosed this information for the first time the day before the witness was scheduled to appear. This is unbelievable. This is starting to sound worse than the Whitmer Fednapping hoax. Graves' office continues to mislead the court and the defendants about actual number of FBI informants, CHSs. There could be dozens as far as anyone knows. The allegations about the existence of yet one or more blah, 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 as we just read, can demonstrate there are reasons to doubt the government's explanation and their justification for withholding information about informants who may be involved in the case. Motion filed by public defender for Zachary Rehl. Rehl is the non-violent defendant denied bail for 2 years by Judge Tim Kelly, who was appointed by Donald Trump, I believe. Hernandez today asked Kelly to reconsider Rehl's incarceration since he has a daughter he's never held since she was born. That is so sad. And Julie goes on to say, as I reported a few weeks ago, the FBI caught red-handed spying on Rehl's communications with his then attorney. The DOJ continues to argue those communications are not privileged because Rehl is behind bars. Also appeared that the FBI was sharing that information with the lead prosecutors. Of course, that was the whole point. So prosecutors knew back in December that the defense planned to call this person as a witness. They had time to prepare for it. For 3 months, not only did Graves' office refuse to disclose the witness was an FBI informant, the individual continued to work as an informant, spying on the defense during trial preparations. You know what we call that, guys? A kangaroo court. That's what that is, with just the appearance of, a legitimate one. And that's very, very concerning. Okay, and then she continues, as everyone fixates on a possible Trump indictment, a massive scandal is rocking the PB's seditious conspiracy trial. And for the second time this month, Judge Kelly has suspended the jury trial amid evidence of FBI misconduct. The U.S. Attorney's Office in D.C. must reply by 1 p.m. to this explosive new filing. Defendants corrected motion to compel disclosure of all FBI interview reports and memos relating to the recording and reporting of the defense team through, an informant inserted to spy on them. Today, the jury was supposed to hear from a defense witness who presumably would testify that there was no PB plan to engage in bad behavior on a certain day, but prosecutors waited until last minute to inform defense that the witness worked as an informant during the entire investigation. The defense says this is just the latest in a string of attempts by the DOJ to withhold, conceal evidence related to numerous, at least 10 FBI informants. More updates this afternoon. Yes, indeed. Okay, so continuing. More from Proud Boys trial this week. Judge Kelly quashed a defense subpoena, all under seal, including hearing of a key defense witness who threatened to plead the fifth. Ken Lizardo was deeply involved with the PBs, but has not been charged. Why? You guessed it. Before the court is Kenneth Lizardo's motion to quash his trial subpoena with defendant Ethan Nordine. Lizardo asserts a blanket Fifth Amendment privilege against testifying on Nordine's behalf. Nordine opposes the motion. Yeah. Then they have an ex parte hearing to discuss it. Lizardo actually picked up Tario from jail, then drove him to the garage for the infamous meetup with Stuart Rhodes the day before that event. one would think his testimony would actually be crucial for the jury to hear, but they won't, thanks to Judge Kelly, which is absolutely ludicrous. So this is from the court filing. Lizardo's connection to this case and the defendants is apparent from the trial record. Lizardo is a PB and was a member of both the MOSD and Boots on the Ground chat groups, as well as some other related ones. The government alleges that the defendants used the MOSD and Boots on the Ground group as platforms to recruit and mobilize select PBs to deploy as part of their conspiracy to use force against the powers that be on a certain date. And although there is evidence those groups were created at least in part for other purposes, several members have been charged in connection with that event. Okay, so here's the other part of this. The record also reveals Lizardo closely interacted with Tarrio, the national leader, in the days leading up to that event. Nichols quested, a documentary filmmaker who had been following Tarrio in the weeks beforehand, testified for the government Lizardo had a quote-unquote close relationship with Tarrio. On January 5, Lizardo picked up Tarrio from D.C. after his arrest the day before. From there, Lizardo drove Tarrio to a parking garage where he met with OK founder Stuart Rhodes, a meeting about which the government elicited information on Quested's direct examination. Of course, before this trial began, a jury convicted Rhodes of SC and other charges related to an event. Quote, reporting relationship with the FBI is a nice way of putting it. That's now what they're calling he's not an informant. He just had a reporting relationship with the government. Lizardo was an informant who now claims he could be charged by DOJ for his participation and must protect himself from potential prosecution. Okay, so let's continue on. This was filed on the 13th. This was Rehl's motion to dismiss and call for an evidentiary hearing. He says, the production of Jenks material related to Special Agent Miller, I believe this is FBI agent Nicole Miller, showed agents reviewed emails between Rehl and his prior counsel related to trial strategy. An agent involved in the investigation states to Miller, quote, this one email definitely indicates that the defendant and his attorney want to go to trial, unquote. The agent says that one of the lead prosecutors should not be alerted yet. Clearly, Rehl's conversation with his lawyer about whether they're going to go to trial or take a plea deal involves trial strategy. Indeed, deciding whether to go to trial is one of the most fundamental issues facing a defendant in a criminal case, especially if it is a federal case, because federal prosecutors have such a high conviction rate. So it's definitely something you need to consider. That's one of the most important conversations that you'll have about your case. Undersigned counsel first reviewed Rehl's emails with his prior counsel this past week after the Miller-Jenks was produced. The government produced the emails in discovery June 17th, 2022, among thousands of other pages of discovery. So Rehl and his counsel, the discovery production did not make reference to the emails between Rehl and his counsel, but indicated, among other things, that, quote, the FPD relativity database has been updated with additional materials, unquote, relating to 19 individuals, including Mr. Rehl. Ordinarily, the government produces case-specific discovery through USAFX. That is their platform for doing that. As a result, Rehl located 15 such email threads dating from October 5th, 2021 through October 15th, 2021. At this point, counsel is concerned that not all emails between Rehl and his counsel have been produced in discovery, both because of the short time period covered in the emails, because some of the comments and the messages between FBI agents are not explicitly found in the 15 email threads, namely the email noting that the government had done things, quote unquote, improperly, and because there appear to be missing FBI messages. Compare fourth message below, which appears to be responding, nope, to an earlier email, which is missing. So they're trying to conceal evidence that they're required to turn over. In claiming that FBI agents did not properly access the messages between Rehl and his attorney, the government relies on several assertions that Mr. Rehl disputes. Accordingly, as more fully set forth below, the government's argument raises factual issues the court cannot resolve on the papers submitted by the government. The government argues Rehl waived attorney-client privilege. He did not. It relies on a document, quote, True Links and electronic messaging, warning, responsibility, and acknowledgement, attached as an exhibit, where it claims a banner warning, inmates are explicitly advised electronic messages and system activity are subject to monitoring and retention. Government corrected response to Nordine's notice of argument at 14. The government's assertion is not accompanied by any sworn declarations by BOP officials, nor does the exhibit contain Rehl's signature or evidence that he had read or accepted such a condition. Which is just ridiculous. That's not true at all. Even if it is being recorded, that still doesn't mean that the federal government and the prosecution are allowed to spy on privileged communications. Okay, so continuing on here, I don't think there's anything else in this one really that we want to address. I think it was just showing that, you know, we already know that they were trying to spy on the defense team and that they were in their communications for trial strategy and stuff like that. It's just crazy. And I thought this was interesting too, while we're discussing that. Merrick Garland recycles dirty spy tactic used in prior prosecution. And we all know what this one is. It was a very big event. The DOJ using FBI informants to spy on defense teams has precedent. Okay, this is from Ken Silva. Attorney General Merrick Garland is allegedly using the same tactic he may have learned nearly 30 years ago when he helped prosecute OKC bad guy Timothy McVeigh, using FBI informants to spy on defense teams. Rehl, one of the defendants in the ongoing PB seditious conspiracy trial, filed a motion Wednesday for the DOJ to provide him with all government records about FBI informants or other witnesses that may have provided the Bureau with information about the defense and specifically trial strategy. Rehl's filing came after he said he learned a person he planned on using as a defense witness had in fact been working as an FBI informant. Quote, during this period of time, the informant had been in contact and then wanted to, prayed with the families, met with families, tried to advise them to fire their lawyers, replace defense counsel. The defendants requested an immediate emergency hearing and adjournment to the court proceedings until these issues have been considered and resolved. The presiding judge reportedly ordered the DOJ to respond today by 9 a.m., and we are now at noon. The DOJ using informants to spy on defense teams has precedent. This is very important. Think, guys, PatCon. This happened to Timothy's defense team in May 1995, right at the time when Merrick Garland was helping the DOJ to prosecute. The May 95 FBI memo said a special agent received information from an informant that a woman named Wilma Sparks was joining Timothy's team. Quote, the informant advised Wilma Sparks is a close associate of the informant and that Sparks is taking on the responsibility of investigating certain aspects of the investigation, the memo said. Quote, Sparks advised the informant that although this was a distasteful assignment, she was willing to accept the assignment to ensure the case against Timothy will not be overturned due to incompetent counsel, unquote. Timothy's lead defense counsel, Stephen Jones, declined to comment on the memo, which was first discovered by Utah attorney Jesse Trentadue and his fellow investigator, Roger Charles. Trentadue used this memo as well as a slew of records showing the FBI had informants in the media to sue the FBI for all records about its, quote, sensitive informant program, unquote, which is used to embed informants in the media, congressional offices, churches, defense teams, and other quote-unquote sensitive institutions. Trentadue's lawsuit was ultimately unsuccessful. As the judge ruled in 2015, the FBI could to exercise FOIA's national security exemptions, keep information about its sensitive informants secret. Trentadue has told Headline USA that he hopes the newly formed House Select Subcommittee to investigate the weaponization of the federal government will resume what his lawsuit started. And wouldn't that be nice? Let's also look at this, because maybe this is going to be a good thing. Hot off the presses, the GAO will soon begin reviewing the FBI's use of quote-unquote assessments, a constitutionally dubious practice that allows the Bureau to target groups and individuals without evidence of criminal wrongdoing. That is super, super important. GAO to investigate dubious FBI surveillance practice. Yes, indeed. FBI assessments have come up in relation to the DOJ's targeting of school board protesters. A report published by @Weaponization revealed there were 25 assessments of school board threats, only one of which resulted in a full investigation, and none of which resulted in charges. However, the impending GAO audit stems from a request more than a year ago from Representatives Mace and Raskin. Specific examples of improper assessments cited by Mace and Raskin include one of a group opposed to the Keystone Pipeline and multiple assessments on, quote, Black identity extremists, unquote, between 2015 and 18, despite the lack of any known connection to crime. Quote, the FBI has opened investigations into people without any evidence of criminal wrongdoing, undermining our right to free speech and due process under the First Amendment, Mace wrote last March. And indeed, that is true. Another excellent and timely piece. This is coming from Richard Booth. The way they use assignments to basically carry out surveillance and investigation without oversight is a huge loophole. And then Ken says, I think this is how they embed sensitive informants. They don't have to launch a formal investigation based on actual criminal wrongdoing. And that's indeed what our documentary will show. That's what happened to Barry and many others in the Whitmer case. And just to touch on what that just referenced about the school board meetings, what the Weaponization Committee discovered. The FBI opened dozens of investigations into parents' conduct at school boards using EDU officials' threat tag. The FBI disclosed after subpoena to Director Wray 25 Guardian assessments, 17 at Criminal Investigative Division, 6 at Counterterror Division, and 2 at WMD Directorate. What? After surveying local law enforcement, U.S. attorneys' offices around America reported back to Maine Justice there was no legitimate law enforcement basis for Attorney General's directive to use federal law enforcement and CT resources to investigate school board-related incidents. Yeah, we already have local law enforcement for that. So anyways, that's just the latest, not just with the Proud Boys defense team here and what the FBI and DOJ were doing. But again, it just shows you that these tactics are not new. How long have they been doing it? What seems to be new is just that we're learning about it and we're talking about it at a national level. But as you saw, these are 30-year-old tactics that Merrick Garland was doing back in the day, all the way back in 1995. So it just continues, and you can see too, look at how that was one high profile case back in 1995. Maybe they weren't doing it to all cases, but because they got away with it, you can see how now that spreads to basically everything. And now they feel like they can get away with doing this to everyone. You know, in their minds, the ends justify the means, and it doesn't matter if they break the law, you know, and that's just crazy. They call themselves the world's premier law enforcement agency, but they're breaking the law. They're withholding evidence. They're infiltrating and spying on defense teams to try to rig trials. That is unbelievable, while at the same time proclaiming themselves defenders of our sacred democracy. So I'm interested in hearing your thoughts on this. Does this information surprise you at all? And what do you think should happen. Do you think that the weaponization committee will investigate this? Do you think they'll look into this? And do you think that there can be anything done now with this trial other than a mistrial? I'm sorry, but how do you continue this case without declaring a mistrial after what we just saw? I don't know. But anyways, that's it for now, and I hope you guys have a good day. Whee!